Hello, my name is Joe Whitcomb, founder and president of the Veterans Advocacy Law Group, and I'm going to spend about the next 3 minutes talking about how your REA, your request for equitable adjustment, may already be a contract claim. So your request for equitable adjustment is sitting on the contracting officer's desk collecting dust, and every day that it sits there, you're losing money, not figuratively. Under the Contract Dispute Act, interest on a valid claim accrues from the date the contracting officer receives it until the government pays, calculated at the Treasury. If your REA is a claim, and it may already be one, the interest clock is already running. If it is not yet a claim, every day you delay converting it to a claim is a day of interest you forfeit permanently. That distinction matters. An REA is a contractor's request to the contractor seeking an adjustment to contracting terms, usually for additional cost or time resulting from the government cost change or constructive change. A CDA claim is a written demand seeking, as a matter of right, payment of money of a sum certain. The two overlap more often in contract agreements. The Federal Circuit confirmed this in Zaffer Construction Company versus the United States in 2022. An REA can itself constitute a CDA claim as a submission of request to sum certain and implicitly or explicitly seeks a final decision from the contracting officer. The form of the document is not controlled. The substance of the document does. If your REA identifies a dollar amount and asks the contracting officer to act, you may already hold a claim, whether you lay what cut rate or not. Certification adds procedural letter. Any claim exceeding $100,000 must be certified. Certification states that the claim is made in good faith, that supporting data are accurate and complete to the contractor's knowledge, and that the amount requested actually and accurately reflects the adjustment for which the contractor believes the government is liable. It's a single element, and the contracting officer can return it without action. One critical prohibition: you cannot split claims to avoid the certification threshold. The Federal Circuit held in Flintway Construction Corporation that artificially dividing a single claim into components below $100,000 to circumvent certification is impermissible. The board and the court will aggregate related claims and require certification. Time is running. CDA imposes a 6-year statute of limitations running from the date the claim occurs. Typically, the date you knew or should have known of the events that you lost. 6 years sounds like a short amount of time until you realize that the REA has been pending for 18 months. The underlying events occurred 2 years before that, and you've consumed more than half of your limitation period without triggering interest or compelling decision. So convert the REA, certify it if required, start the CDA. Veterans Advocacy Law Group provides flat fee claim assistance. You review your REA, identify whether it qualifies as a claim, track the certification language if needed, and submit it to the contracting officer. So call me directly at 3-573-5462. Visit the Veterans Attorney's Contact. Stop losing interest and start the action. This video, please like, share.